Now, as far as the Canadian constitutional law is concerned, you had the British North America Act of 1867, and among the various constitutions, India has a closer similarity to the British North America Act. In fact, if you see the Government of India Act of 1935, you will find that the same concept of a federal legislature or provincial legislature, the items which are conferred on the, in Canada they call it Dominion list, here we call it the federal list, now the Union list, and some topics are given to the state list. One important point is that the lists in the Government of India Act and now the Constitution are much more elaborate than the provisions of the Canadian Constitution under Section 91 or 92. They have only 3 items in the concurrent list. And those of you who want to make a note, concurrent list comes in 94 capital A and 95 of the Canadian. Now it's called the Constitution Act of 1867. So there are 94A and 95 deal with the concurrent list. And it also says that in the event of any conflict, repugnancy, obviously the Dominion list or the federal list will prevail. So this is the basic point. And our own constitution has noted, our own lawmakers have noted, the federal court has noted that we borrow heavily from the Canadian constitution when the Government of India Act was drafted. They say that when the Government of India Act was drafted by the British Parliament in 1935, they drew heavily upon the structure, the architecture of what is the British North America Act. Can I go to the next slide, please? Yes. Now, one very important contribution of the Canadian Constitution is the distribution of legislative power between the center, list 1, list 2, and list 3. And of particular importance is entry 97, which is the residuary power. And that must be read, as you know, with Article 248. Now, this judgment of Union of India versus Dhillon, here what happened was they levied tax on agricultural land, wealth tax on agricultural land. And the Punjab and Haryana High Court, a full bench of 5 judges, by 4:1, they said that that particular provision was bad. Now it came to the Supreme Court, and by of 7 judges, and by a majority of 4:3, they upheld this particular power. Those of you who are making notes, just note entry 86 says that taxation on capital value assets other than agricultural land. Now the argument was, if agricultural land is excluded in the entry 86, can it be taxed under entry 97? And for the purpose of my talk, I'm not getting into this Dhillon's case, but I wanted to mention that in the main judgment of Justice Sikri, Chief Justice Sikri, there's extensive reference to Canadian judgments, how the lists are to be interpreted, how the concurrent list and how the residuary power has to be taken note of has been discussed. But in my humble opinion, the majority is wrong, is incorrect. And if those of you are interested, should read the dissenting opinion of Justice Shelat, who made it very clear that if a particular item has been excluded in list 1, then you can't then justify legislative power under entry 97. But for the purpose of this lecture, Canadian judgments have been extensively referred to in the distribution of legislative power. Of course, subsequently, if you go to Hext Pharmaceuticals and other judgments, wherever there's a discussion of Article 245, 246, List 1, List 2, List 3, etc., they have referred to the Canadian judgments. Please, next slide. Now, a very important contribution which Canadian law has made is the doctrine of Pith and Substance. And one of the outstanding judgments of the federal court is Subramanian Chettiar versus Muthuswamy Gounder, where it related to debt relief. And there, the Privy Council said, the Privy Council decisions from Canada, from Canada, they used to go to the Privy Council. Now, of course, they've got their own Supreme Court. But earlier, many judgments would go to the Privy Council on Canadian constitutional law. And there are important judgments. All of us know Attorney General for Canada versus Attorney General Ontario. Then the aspect theory cases, all of them went to Privy Council. The federal court remarks that because the structure of the Government of India Act and the Indian Constitution is similar, the Canadian principles are entitled to greatest weight. I'm sorry, it's height, it should be weight. And they serve as a very useful guide for this particular purpose. Then you next go to A.S. Krishna's case, where again, the case came from Madras, where they explain how this doctrine had been evolved. The judgment of T.S. Venkatarama here has very nicely explained how this particular doctrine has come. If you're interested, it's in paragraph 8 of this particular judgment. Next slide. Now, one latest contribution of aspect theory is from Canada. And this judgment is a landmark ruling of 7 judges. The majority judgment is by Justice Venkatchalaya. And the concurring view of Justice Ranganathan is equally important. Sadly, he passed away this morning at 12:30 a.m. One of our very, very great judges. Those who are interested, please see his dissenting opinion in the Antule judgment. I think, if I'm not mistaken, from para 142 to 192, 50 paragraphs, he dissented from the majority view, and it's a masterpiece by itself. Coming back to aspect theory, in the Federation of Hotel case, what they did was they levied expenditure tax if you spend money in expensive hotels. So Mr. Palkhiwala argued that this is nothing but in Pith and Substance, a luxury tax. It should come under entry 62, it can't come under this. He said, yes, you can levy expenditure on all. There was an expenditure tax act for some time. It was on all kinds of expenditure. There's no problem. But if you tax only an expensive item like a 5-star hotel or a luxury, then it amounts to a luxury tax. In Pith and Substance, it comes under entry 62 of list 2, and cannot be done. Then they said no, they evolved the aspect theory. And when I spoke to Justice Venkatchalaya and some other context, he said they were struggling to get over Palkhiwala's arguments. And then Mr. Parasaran referred to this Canadian Constitution. And he said that we are not taxing the luxury, we are taxing the expenditure aspect of it. And they applied the aspect theory. In my humble opinion, this is a wrong application. Aspect theory should have no place in the Indian constitutional law. But unfortunately, it has been applied. For example, in the case of service tax on leasing transactions. Now, lease is deemed to be a sale by the 46th Amendment. So in Pith and Substance, when you tax a lease, you are levying sales tax. Simple as that. Now, it is also settled by the Supreme Court that when you levy sales tax, you are levying tax on the principal component and on the interest component. In a leasing transaction, hire purchase transaction, in the EMI, monthly installment you pay, there is a principal component and an interest component. And the value of sale includes everything. Now, once it is taxed as sale, you can't levy service tax on the interest portion. But the Supreme Court in All India Federation case said, no, interest aspect can be taxed separately. According to me, that's completely wrong. There is no time to get into this, but this is an unfortunate point which should not have come. I personally feel we should go by the Pith and Substance theory. If a leasing transaction is in Pith and Substance, a sale, and it's a sale levy subject to sales tax, it can come only under list 2. You can't again levy it on the interest part. Similarly, profession tax, it's coming under entry 60 of list 2. Tax a profession. Now, you can't say that profession tax is paid whether or not I become an advocate or I practice in the court. When I do actual service, I am rendering profession tax. It's completely wrong. The right approach is by Justice Chinnappa Reddy in this International Tourist Corporation case. Those of you interested can note down. It is AIR 1981 Supreme Court, page 774. There, Justice Chinnappa Reddy says how to interpret the list. He says go to list 2. All of us studied in law college that lists should be given a liberal interpretation. Now, if you liberally interpret list 2, if what is sought to be taxed or what is sought to be legislated can come within the liberal interpretation of list 2, then it can't be taxed under entry 97. This is the clear judgment, which unfortunately was distinguished and followed. But aspect theory is a Canadian concept which should not be applied, is my humble opinion. I hope sometime there's a 7-judge bench which overrules this. God knows what will happen in the future. Thank you. Next slide, please. This is a very important one. Proportionality. In the case of R versus Oakes, there was a case of proportionality, and that concept has now been imported into India. And if you see the aspect of proportionality in R versus Oakes, how did this proportionality come? Very interestingly, they said that for narcotic cases, the burden of proof shifts to the accused. Accused has to prove his innocence. That was struck down as being violative of Section 11D of the Charter of Freedoms of Canada. And they laid down 3 tests of proportionality that has been referred to in modern dental college. Justice Sikri has very nicely explained the concept of proportionality. And those of you interested can see there's a separate book by Aaron Barak, the Chief Justice of Israel, a very beautiful book on proportionality. So we get from Canada we get Pith and Substance, we get aspect theory, we get proportionality. All these concepts have come in from the Canadian Constitution. Next slide, please. Hate speech. Now, coming to recent times, there is what is called the Whatcott rationale. There were some speeches or some social media, etc., against immigrants. And then the Canadian Constitution laid down what are the tests which amount to hate speech. And they said that a speech will be treated as hateful if it leads to vilification of a class of people or leads other people to detest that class. So that is the two-stage test which was given for hate speech, and that has been followed in Pravasi Bhalai, which deals with migrant labor, interstate migrant labor. So this concept of a very good discussion on what amounts to hate speech, how it should be not be encouraged. So there's a kind of a objective test laid down as to what amounts to hate speech. Next. Yes. Now, this is also a doctrine of indirect discrimination. It's a very interesting concept laid down in the Ontario human rights case. This was applied where women were recruited into the armed forces, and they said that, look, you can't disallow women from entering the armed forces. Now, indirect discrimination. So when you use indirect, automatically you think of direct. So the Canadian Constitution Supreme Court says direct is something which is patently obvious. You can easily see this is direct. But when you go to indirect, it is latent. It apparently looks like it is equal, but actually when you examine it in detail, it amounts to indirect discrimination. These are very interesting concepts, but due to constraints of time, I am not getting into them. So this is another interesting doctrine of a recent origin which we have got. You'll find that this Pith and Substance, etc., has come much earlier, but in the last few years, hate speech, indirect discrimination, we have borrowed from, we have taken the help of, or at least used these constitutional cases from Canada as our basis. In fact, I'll also mention, before we just go to the previous slide, in the Tribunals case which I had argued for Madras Bar Association, and Justice Rohinton Nariman's concurring view in the judgment which he struck down the National Tax Tribunal Act. There what happened was, they said that there'll be a national tax tribunal. The High Court's jurisdiction in all taxes, direct, indirect, will completely go. It will all go to the National Tax Tribunal. Now, there is extensive discussion in Canada on what is the role of tribunals vis-a-vis courts. And one interesting case I must point out, look at the approach. Unfortunately, our Supreme Court has given much more leeway to the government to get into tribunals, which in my humble opinion was a wrong step. But anyway, in Canada, there is a judgment called in re residential tenancies. In re residential tenancies. There was a huge housing shortage. There were a lot of rent control cases, more than 100,000 cases pending in Canada. It was a serious problem. So they formed what is called a Green Commission. Mr. Green was the chairperson. He formed a commission and he said, look, there are too many rent control cases. Why don't we start rent control tribunals manned by a judicial member, technical member, etc. So the load from the courts are taken away and the tribunals can decide the matter. And usual thing, tribunals are faster. There are no strict rules of evidence. It'll be cheaper justice. All these usual arguments were made. In an outstanding judgment of 7 judges, they said judicial power can never go outside the judiciary. And in fact, the UK Supreme Court has held there can be overlap between legislative power and executive power. We talk of separation of powers. We say there is no strict separation, there can be some overlapping. But the UK Supreme Court has held that there can be overlapping between legislative and executive power, but they cannot be a mixture of judicial power with other powers. So the Canadian Supreme Court said, if you got too many rent control cases, the solution is start more civil courts to deal with this problem. You can't say that because the courts are flooded, I will start tribunals and then allow them to be manned by retired civil servants and so on. That's not possible. So Justice Nariman has extensively referred to, there are 4 Canadian Supreme Court judgments on what is tribunals, quasi-judicial power, etc. And he eventually struck that thing down. I forgot to mention it here, but it just occurred to me that we held enormously by the Canadian judgments in striking down the National Tax Tribunal case. Otherwise, see now company law has gone straight to the Supreme Court. If tax tribunal had gone, there'll be no tax at all in any high court. And I had remarked at that time in arguing the case, I said that you'll have a situation where judges will go to the Supreme Court who have never dealt with the company law and never dealt with tax, because all tax cases have gone to the Supreme Court. But luckily, that was at least struck down, and the tax jurisdiction of the High Courts has been preserved. Incidentally, our basic argument to the Madras Bar Association was High Courts decide substantial questions of law in tax matters. 260A, central excise, only substantial question. The tribunal decides other matters. So I said that this is a core judicial power which can never go outside the judiciary. And I used the Canadian judgments for that, and we succeeded. Next. Next, please. Yes, I have now, whatever interesting articles, I have put them on the slide. Those who want to follow it, these are interesting points which more elaborate. Those who are interested in going more deep into the Canadian aspects of what Canadian contribution is can read these 2 slides, 8 and next 2 pages. I've just collected, my interns have collected these slides, this research material which can be useful. Next, please. Next. Yes. Now, yes, that's it. Next, please. Now I go to the US Constitution. There has been a large number of cases of the where we have referred to US Constitution. In fact, we are doing some research, and we find that author like Willis, I mean, we all referred to Cooley on Constitution, referred to Rotschaffer. These are all authors we have referred to. Recently, we referred to Lawrence Tribe. Then you got Mark Tushnet, who's written on comparative constitutional law. But an author like Willis on constitutional law has been referred to in 25 Supreme Court judgments and 106 High Court judgments. Just to give you a flavor that there has been extensive reference to US constitutional law in our High Courts and in our Supreme Court. Now, if you go to the US Constitution, we have a large number of similarities between the US Constitution and our Constitution. For example, I've just mentioned the 8th Amendment, which 8th Amendment was relied upon by the Maneka Gandhi in saying that